Hi everyone, welcome to week 8 lecture number 2. Today I'll cover executive orders and the judicial system. First, I'll start by discussing what executive orders are and their history of usage pertaining to natural resource management. Then we'll delve into the judicial system, examining common law and the way that the judicial system has kind of evolved over time pertaining to natural resources law, and then end the lecture with a brief discussion of some recent litigation and recent happenings in natural resource law. Topic number 1, executive orders. What is an executive order? Essentially, it's a document that's written and signed by the president that directs the actions of the federal government. So it's not a law, but it does get reviewed by the judiciary. Executive orders have been used by virtually every president of the U.S. On average, the president makes about 3 executive orders per month. So most of these executive orders are quite routine, they're non-emergency, they're not controversial, but executive orders are also used to direct federal agencies in the case of emergencies, or they could be used for declaring war. Next, let's look at some of the specific executive orders that have been really influential in natural resources management in the United States. So first, we're starting in 1972 with this executive order that was issued by President Richard Nixon. So a common practice at the time was to use chemical deterrents and poisons to help protect sheep that were grazing on federal lands from being harassed by coyotes. Unfortunately, they were using these compounds in like poisoned bait piles or non-specific applications where lots of non-target wildlife were also being affected. So this executive order directed the government to stop using these chemicals in such a generalized fashion, and they needed to be more careful about understanding the birds, mammals, reptiles, and especially predators or any rare species that could be potentially affected unintentionally. As a result, there was new emphasis put on changing the practices of the time. They did more research on non-lethal ways to deter nuisance wildlife, and they also did research into different methods of using those same chemicals that could be safer, like this anti-predation collar on the sheep in this diagram. Next, we're looking at how we handle invasive species. So in 1999, President Bill Clinton issued this executive order directing the government to be more targeted and proactive with preventing invasive species from being introduced and getting established. And this executive order also empowered the government to be able to take more action to stop the spread of invasive species that were already here. So as a result of this executive order, the National Invasive Species Council was established, and they came up with a management plan that also featured a science-based risk evaluation procedure to assess which species had the potential to be especially detrimental invasives. As we know through our own careers and experiences, there's been growing emphasis put on cooperative conservation decision-making. We know it's so important to involve stakeholders as we're making decisions and implementing management plans. So this executive order issued by George W. Bush in 2004 really kind of capitalized on that existing momentum, and this executive order directed the government to be very intentional in the way that it's implementing its existing environmental laws, so that it ensured that tribes and local governments and states and local communities truly had a voice in implementing conservation practices. So as a result of this executive order, federal funding was directed into a collaborative conference held each year, and as well as collaborative venues where this kind of group decision making could be implemented. They also produce an annual report, and overall we've seen increased engagement with the federal government in reaching out to local entities when working on conservation planning. Ongoing problems with wildlife trafficking led President Barack Obama in 2013 to issue this executive order that directed the government to combat wildlife trafficking, specifically giving the government an imperative to assist foreign nations, address trafficking issues in their countries, and help them establish better plans and enforcement strategies. Domestically, we also put new emphasis on enforcement strategies and really enhancing the follow through on uncovering trafficking issues and trying to address some of the root causes, both socially and economically, for why wildlife trafficking is happening. So this executive order created the Presidential Task Force on Wildlife Trafficking. It has members from 15 different departments and agencies from the federal government, and they developed a national strategy for combating wildlife trafficking. Finally, quite recently, earlier this year, President Joe Biden issued executive order that built upon a previous executive order from about 30 years ago, federal actions to address environmental justice in minority populations and low-income populations. This executive order had been successful and it's well regarded. So the new executive order just reaffirmed and kind of re-strengthened the government's commitment to delivering environmental justice to at-risk populations and communities. So now governmental organizations have to develop and submit environmental justice plans, and it also gives the government an imperative to analyze its own actions as it influences climate change and environmental burdens for sensitive populations. Now there is an environmental justice subcommittee of the National Science and Technology Council. So to wrap up this section of executive orders, here is a little refresher from grade school about how checks and balances work within our government. So the president has executive authority to direct the activities of the federal government via the executive orders. Then the judicial branch of the government is able to review those executive orders and ensure that they are within the power and purview of the federal government to take those actions. And then at the same time, the judicial branch of the government also, of course, hears court cases and has opportunities to review legislation. So all of this is quite important to how we are approaching all of our environmental conservation within the nation. Therefore, we are switching gears now to talk about the judicial system. A brief overview of judicial systems worldwide. On this map, the countries in blue have a civil law judicial system, and this is based on written codes and statutes that have been enacted by legislature. So essentially their legal system or judicial system is based on laws, written laws. In contrast, England and former English colonies use a common law judicial system. So this includes the United States. What is common law? So common law is based on courtroom decisions and rulings, not based on statutes and codes. So the core principles and foundations of common law are these three things: property, contract, and tort. So property is the idea that people have a right to their possessions and their creations. Contract means people have a right to make mutual agreements to exchange goods or services with other people, and the other party will uphold that mutual agreement. And then tort. Tort means that if your rights have been violated or transgressed, then you have the right to seek to rectify that. So if someone steals your possessions or destroys your belongings, if someone breaches a contract that they made with you, tort means you can seek recompense for that. What are the origins of common law? So it began in England with the creation of the Magna Carta in 1215. The Magna Carta created the English Court of Common Pleas. So this was a venue where the common person could go and air their grievances, so to speak. They could resolve their interpersonal disputes. And this formed a basis for courtroom type hearings. And as the Court of Common Pleas operated over time, they built up a foundation of many cases and rulings that would be referenced for future decision making. Sir Edward Coke was an important person in the evolution of common law over time, so you don't necessarily need to know his story, but suffice to say, it is kind of interesting if you want to look it up. Essentially, he held a number of different positions within the English judicial system. He served as the Chief Justice for the Court of Common Pleas, and he was a very strong proponent of the common law and essentially the common person's rights to their property and to contract and tort. Sir Edward Coke represented Queen Elizabeth I in the case of swans in 1592. Briefly, the law in England was that swans were regarded as royal fowl, so they belonged to the monarch. In this case, Queen Elizabeth was seeking to round up 400 swans that were living in Dorset County. Locally, the swans had by tradition been owned by the abbot of the local monastery. Then a previous monarch, King Henry VIII, had dissolved the monastery and granted the estate to Giles Strangways, who was just a citizen. Then when Giles Strangways passed away, he had deeded his estate and the swans to his widow, Dame Joan Young, who presently possessed the swans. So the case boils down to this question: who owned the swans? Were they actually Strangways' property, and then was he therefore allowed to deed them or grant them to his wife? Or did the swans belong to the Queen? And what the court ruled was that swans were ferae naturae, meaning by the legal definition, they were wild animals. They didn't belong to any one person, and therefore they couldn't be given in transfer or possessed by a citizen. So while the swans, yes, were owned by the Queen of England, the importance of this case was that it created this, this courtroom ruling, this contribution to common law that confirms that wild animals are exactly that. They're wild animals. They don't necessarily belong to whomever's land they reside on. Over time, as the United States formed as its own country and as it matured in time, it borrowed heavily from English common law until the U.S. had built up enough of its own case history to base its courtroom rulings and decisions on. It then became common practice for the courts in America to publish their rulings and publish opinions from judges and juries. This created a written record of case law and rulings. And so over time, our current judicial system now relies really heavily on common law on all of these decisions that were made prior. Those can now be referenced as new cases are brought into trial. So how does common law relate to the environment? How does it protect our natural resources? So think back on the foundations of common law. Common law allowed the people to protect themselves from pollution. It meant that, I have my property and I have a right for it to be clean the way I want it to. If my neighbor is polluting my property, then, I can address that with them. Like, I can take legal action with them about it. And so these common law practices and all of these compounding court rulings over time really kind of solidified our ideas about, what do we own versus what needs to be held in the public trust. And this established a foundation for what have now become a lot of our modern statutes that legally, in law, in the legislature, they protect the environment. Next, we'll look at some of the foundational cases in U.S. common law. The first being Pearson versus Post in 1805. This is the most famous property law case in American history, and interestingly enough, it has to deal with wildlife. So this court case helped to decide at what point does a wild animal become someone's property. So Post was hunting a fox. He was in pursuit of the fox. Then Pearson saw the fox and shot and killed the fox. Post filed a lawsuit against Pearson, essentially claiming, I saw it first, it's my fox. Ultimately, the court ruled in favor of Pearson, saying that this animal was wild. It didn't belong to anyone until you, Pearson, actually shot and killed it. Then it becomes your property. So this was very important for property law in general, but naturally we can see how this is also kind of upholding our concept of wild animals don't belong to any one person until they've been harvested in a legal manner. The next case is Genn versus Rich in 1881. Genn was a whaler. He used a harpoon to kill a finback whale, and on that harpoon was his name. So the whale sank, which was somewhat common, so Genn wasn't able to retrieve the whale at that time. Later on, another man, Ellis, found the whale washed up on the beach, and he disregarded the name on the lance that had killed the whale. He decided to auction that whale. Rich then bought the whale and processed it into whale oil, etc. When Genn found out about this, he brought Rich to trial. And so practice at the time, which was supported by common law, was that by killing the whale with a lance that has your name on it or your whaling company's name on it, that is you proving that that whale was yours and you were responsible for taking that whale, i.e. it became property when you killed it. And so the judge did rule in favor of Genn, saying that he was the rightful owner of the whale because he killed the whale. So once again, you can imagine how foundational cases like this were quite important for refining our principles, our treatment of wild animals and natural resources. When are they out there free versus when do they become something that someone can own and determine the fate of? Now let's look at a more recent case in wildlife and natural resources law. So in 2002, the state of Wyoming was seeking to vaccinate elk residing on a national elk refuge, a federal land, within the borders of the state of Wyoming. They wanted to vaccinate them against brucellosis. So brucellosis is a bacterium-based disease that can spread between domestic cattle and wild elk. Wyoming had already been vaccinating cattle that grazed on state lands since the 1980s, and that was keeping the cattle industry for the state well and thriving. But they were concerned that the wild elk on this national elk refuge were harboring brucellosis and could be spreading the disease back and forth to the cattle as well as state-managed wildlife on state lands. So they requested to vaccinate the elk on the national refuge. The federal government said no. Wyoming took them to court, and what the judge decided was that based on the 10th Amendment, the states actually didn't have exclusive right to manage wildlife within the state's boundaries. They decided that the National Wildlife Refuge System Improvements Act, as well as the domain of the federal government or their regulatory purview, meant that the federal decision would take precedence over what the state wanted to do with those wildlife, with those elk. And so this is an important court case because it kind of deals with this tug of war, sort of this back and forth of who has say over wildlife, who gets the ultimate authority to make decisions about how these wildlife are managed. Should it be the state? Should it be the federal government? Something in between? I think most importantly, as cases like this happen, we as professionals need to be tuned into them because of the precedents that these court decisions have, the precedents they set, and the weight that carries under our common law system. Finally, I'll cover the Equal Access to Justice Act of 1988. So this was an act passed in order to help the little guy seek justice against the federal government. So essentially, if veterans, the disabled, small businesses, local communities, or even individuals, as they feel that their rights or liberties have been transgressed by the federal government, this act makes it easier for them to bring a lawsuit against the federal government, because if they prevail, if they win their case against the government, then that governmental agency pays their legal fees so that the small guy can challenge the government without necessarily going into debt over the legal fees. In essence, this act is a good thing, right? It helps hold the federal government accountable. However, there have been controversies surrounding this act, especially with environmental litigation recently. So there's this loophole in the act that doesn't adequately constrain the size of the organization that's bringing litigation against the government. So certain big organizations like the Center for Biological Diversity were able to, they had plenty of money, but they were still able to bring many, many lawsuits against the federal government, and they got the payout, even though they aren't truly in the spirit of the law. They aren't the little guy. They were still kind of exploiting this loophole and draining funds and drawing down government time unnecessarily. And this got plenty of environmental groups upset because a lot of these lawsuits were targeting the Department of the Interior, the U.S. Fish and Wildlife Service, and specifically the Endangered Species Act. And some of these lawsuits weren't necessarily based on science and fact, and more so seemed to be aimed at wasting government time. So there's been a lot of back and forth on this, and a recent act, the John D. Dingle Jr. Conservation Management and Recreation Act, just from 2019, now requires the federal government agencies to create an annual report listing how many lawsuits were brought against them under the EAJA and how much money they had to pay out. So it's pretty interesting. You can Google it and look it up if you want to see. But so the significance of this is, once again, we're grappling with, who gets a say in how wildlife are managed, and what's worthwhile battle to fight versus what is going to waste government time and maybe make it less efficient for everyone. So in conclusion, executive orders are a pretty fast-acting and targeted way for the president to take action and direct the actions of the federal government, and this has been used to great positive effect for environmental protections and environmental causes over time. The judicial branch plays an important role in environmental and natural resources management via the checks and balances and the way that the judiciary gets to review laws and preside over court cases. The common law system of the United States, which was originated in England, created a lot of foundational principles that are now guiding environmental policy in the United States. And then finally, contemporary litigation and new acts and laws that are being passed are, setting precedent for how these kinds of natural resources management and conservation decisions will be made in the future. Review questions. Number 1, define executive order and describe how executive orders have been used to regulate environmental management. Number 2, describe the role of the judicial system in environmental protections in the U.S. via checks and balances and reviewing laws. And finally, number 3, define common law and its role in American property law. References. And thank you. So I really look forward to interacting with everybody in the discussion exercise for this week's class. Thank you.